At 10:18 on a quiet Tuesday morning, I was standing at my own mailbox when a police cruiser rolled up and changed the course of someone's career. I wasn't yelling, I wasn't running, I wasn't doing anything except flipping through junk mail and a water bill. 20 minutes later, I was in handcuffs in the back of a patrol car, and the young officer driving had no idea he'd just arrested a constitutional law professor on her own driveway. Yeah, that happened. You have to understand the neighborhood was one of those places where the loudest sound most days is a lawn service or a dog barking at nothing. Brookhaven Heights isn't flashy, but it's comfortable. Brick mailboxes, trimmed hedges, delivery trucks moving slow like they've got all day. I'd lived there almost 2 decades. That morning I was wearing gardening pants and old blue cardigan, reading glasses sliding down my nose. I had just pulled a stack of envelopes from the mailbox and was sorting through them. Bills in one hand, junk in the other. When I noticed the cruiser creeping down the street, I glanced up, gave a polite half-second look, then went back to my mail. You know that instinct you get when you can feel someone watching you? That's what it felt like. The car slowed even more. Then it stopped. And then the lights came on. Not sirens, just the red and blue flashing against my glasses like I'd done something worth announcing. The officer who stepped out looked young enough to be one of my students, Officer Daniel Reed. Fresh face, new uniform, stiffness, that energy of someone who's still trying to prove himself. He adjusted his belt as he approached, shoulders squared like he'd rehearsed this in the mirror. "Morning, ma'am," he said. "Do you live here?" I remember lowering the envelope slowly because I wanted to make sure my voice was calm. "Good morning, officer. I'm retrieving my mail. Is there a reason you've activated your emergency lights?" He blinked like he didn't expect a question back. "I asked if you live here. We've had reports of theft in the area. I need to see some ID. Now, I've spent 30 years teaching the Constitution. I've argued appellate cases, trained young attorneys, lectured on search and seizure law to rooms full of people who carry badges. So when he said that my mind didn't go to fear, it went straight to analysis. Reasonable suspicion, articulable facts, probable cause. None of it was there. "Officer," I asked gently, "am I being detained?" "I'm conducting an investigation." "Based on what specific suspicion?" He didn't like that. I could see it in his jaw. He stepped closer. "If you're not doing anything wrong, just show your ID." That line, I've heard it in courtrooms and body cam footage and stories from clients. It sounds simple, it sounds harmless. But rights don't work that way. If the government can demand your identification without a lawful basis, then the Fourth Amendment is just decoration. "I'm standing at my own mailbox," I said. "You need reasonable suspicion to detain me. You haven't articulated any." Across the street, my neighbor, Mrs. Ellison, had stepped onto her porch. She's in her 70s, sweet as pie, but sharp. She saw the lights. She saw his posture. She pulled out her phone and started recording. Smart woman. Daniel noticed and something shifted. Instead of stepping back, instead of reassessing, he stiffened. Pride is a powerful thing, especially in a young officer who thinks backing down means losing. "Turn around," he said. "On what grounds?" I asked. "Failure to identify. Obstruction." "I am not obstructing," I replied, steady as I could make it. "I am asserting my rights." You could feel the tension crackle. The birds stopped. Even the air felt heavy. He stepped into my space close enough that I could smell his aftershave. "Turn around," he repeated. "I am not resisting," I said clearly because I knew the body camera was recording. "I do not consent to this seizure." Then his hand closed around my wrist. Quick, forceful. He twisted my arm behind my back harder than he needed to. Pain shot up my shoulder, but I didn't pull away. I didn't want to give him anything he could call resistance. The cuffs snapped shut, cold metal biting into skin that had done nothing wrong. Mrs. Ellison's voice floated across the street. "Naomi, are you all right?" "I'm fine," I called back. "Please keep recording." Daniel guided me down my own driveway like I was some porch pirate he'd caught red-handed. "You can argue it in court," he muttered. "Oh, I intend to," I said softly. The ride to the station was quiet at first. He seemed almost energized, like he'd won something. Halfway there, he glanced in the mirror. "If you'd just shown your ID, none of this would have happened." I looked out the window at trees I'd driven past 1,000 times. "Officer," I said, voice steady, "I'm invoking my right to remain silent." Then I added because I couldn't help myself. "You might consider doing the same." When we got to the precinct, the shift sergeant Mark Delaney looked up and frowned. A handcuffed grandmother in gardening clothes doesn't exactly scream public menace. "What have we got?" he asked. "Disorderly failure to ID resisting," Daniel said. "I did not resist," I corrected calmly. "And I would appreciate these removed." Delaney opened my wallet to verify identity. He saw my driver's license first, then my university ID. His expression changed. He looked up at me, then back down at the card. "Dr. Naomi Carter." I nodded. The room went quiet. He closed the wallet slowly and looked at Daniel in a way I'll never forget. Like a father realizing his kid just did something irreversible. Do you know who this is? Some lady who would not cooperate, Daniel shrugged. Professor Carter lectures on constitutional law, Delaney said carefully. She's trained half this department. I watched the color drain from Daniel's face. The cuffs came off quickly after that. My wrists were already red indented with little crescent marks that would last days. I want the body cam footage preserved, I said. Dashcam dispatch logs, all of it. The lieutenant came in offering apologies and damage control. We can just consider this a misunderstanding, he suggested, almost hopeful. No, I said, meeting his eyes. This was a custodial arrest. I was seized, transported, and booked. Please don't insult my intelligence. My husband arrived 20 minutes later. He's an attorney too, and when he saw my wrists, his jaw clenched the way mine had earlier. We didn't yell, we didn't threaten, we just asked for documentation. Because that's how you win these things. Not with volume, but with precision. 2 days later, we filed a federal civil rights lawsuit. The complaint wasn't emotional, it was clinical. Timestamp by timestamp, it laid out exactly what happened. Every command, every misstatement of the law, every unnecessary escalation. When the footage hit the media, it spread fast. You could see the whole thing, the mailbox, the questions, the cuffs. Legal analysts called it textbook unlawful detention. Civil rights advocates shared it. Strangers who'd never met me debated it online like it was their own story. Internal affairs moved quickly. Suspension came first, then the hearing. His union argued inexperienced training culture, proactive policing. And maybe there's some truth in that. Departments sometimes reward aggression more than judgment. But when the chief asked him one simple question, would you have stopped her if she were a white woman? He didn't answer. He was terminated for civil rights violations, added to a Brady list, which means his credibility is forever compromised in court. That's the kind of mark that follows you. The city settled before trial, a 7-figure number. People asked me if that felt like victory. It didn't feel like winning. It felt like acknowledgement. It felt like the system admitting it got something wrong. I used part of that settlement to fund a legal initiative for people who can't afford representation when they're targeted in stops like that. Because here's the part that keeps me up at night. I knew the law. I had resources. I had colleagues who could draft a complaint in their sleep. What happens to someone who doesn't? You know what I mean. I went back to teaching the next semester. The lecture hall was packed. I stood at the podium, adjusted my glasses, and played the video of my own arrest. The room was silent. When it ended, I told them, the Fourth Amendment is not theoretical. It is a boundary between power and liberty. And boundaries only work when someone is willing to enforce them. Some people think Daniel's punishment was too harsh. They say he was young, that he made a mistake. Others think it wasn't harsh enough, that an unlawful arrest with physical force should carry criminal consequences. I've heard both sides. I understand both arguments. But here's what I know. Ego escalated that encounter, not evidence. Pride overrode prudence. And once the cuffs clicked shut, there was no quiet way to walk it back. So I want to ask you, where's the line? When does proactive policing become unconstitutional? When does authority tip into arrogance? Have you ever been in a situation where standing your ground cost you something, or maybe saved you? Drop your thoughts in the comments. Tell me if you think the settlement was enough or if there should have been more accountability. Share a story if you've lived something similar. Because conversations like this matter. They remind us that rights aren't self-executing. They depend on people willing to assert them and systems willing to respect them. If this story stayed with you, share it with someone who needs to hear it. And if you believe that accountability should apply to everyone, especially those entrusted with power, hit subscribe and stay in this